Hello, everybody. Welcome back to UPC Insights, your go-to podcast for the latest on patent law and practice in Europe and beyond. I'm your host, George Walden, and today we're discussing two topics which are both highly technical and legally significant: equivalent patent infringement and file wrapper estoppel, concepts that impact the scope of patent protection and enforcement. And also, we do our best to keep you up to date here at the UPC Insights podcast by finding distinguished UPC representatives and guests to talk about the current state of affairs at the UPC and possible trends. And today is no exception. Before I introduce our next guest, let me give you a little background on him. His name is Patrick T. Muffo. He's currently working at the prestigious U.S. law firm of Polsinelli. I think that's in Chicago, on the Riverside, Plaza Suite 3000, if I can remember my Chicago days well. He is also a shareholder, and he specializes in the intellectual property, post-grant proceedings, intellectual property litigation, mechanical engineering, and medical devices patent prosecution. That's a lot. He studied intellectual property at the law School of the University of New Hampshire at the Franklin Pierce School of Law, and he has a bachelor's degree, magna cum laude, I have to say, from Virginia Tech University, or better known as Virginia Polytechnic Institute and State University. We had to give a shout out to the Hokies Nations, as I spent a lot of time in Blacksburg myself. I did a lot of campus jumping on the weekends at Old Dominion, William and Mary, and Hampton University, etc. But without further ado, ladies and gentlemen, please welcome Patrick to the show. Patrick.
Thank you, George. That was quite the introduction. And maybe after the podcast, we'll have to discuss your days of hopping around campuses in Virginia. That sounds like an interesting story that we'll have to dive into.
We definitely will. We definitely will. And of course, we have our stalwart expert, Mr. Tilman Pfrang, an resident expert on the UPC case law, and he'll help us explore how the US and Europe approach these doctrines and what patent holders need to know when protecting their rights globally. So, ladies and gentlemen, let's get started. Gentlemen, are you ready?
Absolutely ready.
Let's do it.
Here.
You got it. So, Pat, this first question goes to you with the basics and definitions. Can you briefly explain how equivalent patent infringement is treated under the U.S. law? And I believe the doctrine of equivalence plays a big role here, or?
Yeah, so the doctrine of equivalence, I think of it sort of as a close enough infringement, meaning the patent owner has not shown literal infringement of the claim, but has shown that the accused product or process is close enough to the claim that infringement is found. And here in the US, and I won't go into the details of this, but the two tests we have for doctrine of equivalence are the insubstantial differences test and the function weight results test, which the function weight results test is actually a derivative of the insubstantial differences test. So many would nitpick and say that's actually one test, but I think as a practical matter, they're applied separately and differently given the context of the case. But as a practical matter, doctrine of equivalence is really sort of a weaker argument for a patent owner, typically, than literal infringement. It's harder to prove, and there are lots of challenges, lots of legal bases for knocking the argument out of court. And it's a very interesting topic because we think of patents as having this well-delineated scope of protection, and the doctrine of equivalence is sort of that fuzzy boundary on the outside. So that's the U.S. perspective in a nutshell, and I look forward to getting into the details and the nitty-gritty of it.
Okay, I'm looking forward to some of that fuzziness as well. Okay, so Tilman, can you give us a brief overview of how the concept of equivalent infringement is handled under the unified patent court system? And are there any differences from the traditional approaches seen in national courts like Germany and the UK?
Yeah, I can try to give you an overview. George, the Unified Patent Court has recently begun to establish its approach to equivalent patent infringement through its initial rulings. Of course, based on the provisions of the law, which means Article 69 of the EPC and its protocol explicitly mentioning equivalence is of greater importance. Notably, in the Plantee versus Bayou case, the local division in The Hague applied a 4-step test to assess infringement by equivalence, comprising the following steps. There must be technical equivalence. So does the variation solve essentially the same problem and perform essentially the same function as the patent invention? There must be a fair protection for the patentee. So that's the second step. Fair protection for the patentee. Question: is extending the protection of the claim to the equivalent proportionate to a fair protection for the patentee? which step covers specifically questions like how big is the invention and is the alleged infringing embodiment obvious for the skilled person in view of the patent.
So, I mean, that's...
Third step. Let me finish.
Okay.
You asked for a brief overview. This will not happen. Third step. Reasonably legal certainty for third parties. So does the skilled person understand from the patent that the scope of the invention is broader than what is claimed literally? Last step. You must be patient, George. Last step. Novelty and inventive over the prior art. Is the alleged infringing product novel and inventive over the prior art? So this is the basic ruling on equivalence we have so far, that the Hague division. There was even an earlier decision of the Hamburg local division, but this was not so detailed, and actually they more or less, well, there is no same effect, and therefore it's no equivalent infringement. In another case, though, and this is very interesting for our topic today, the Brussels local division examined also the equivalence using tests I think Pat has already mentioned, namely the function way result test,
right,
and the insubstantial differences test. So those two tests are, from my perspective, and also from many other national jurisdictions, as far as I know, kind of at least a new wording, which whether it's a completely new concept is to be seen, but at least a very new wording inspired or based on US practice. So obviously the UPC is developing its own jurisdiction, but also considers principles from national jurisdictions like Germany, by the way, and now also the US.
Wow. Okay. Well, then moving on with the second part of the question to doctrines of equivalence and the file wrapper Estoppel. Pat, the doctrine of equivalence seems like a powerful tool for patent holders in the US, but there's also the concept of file wrapper Estoppel that can limit it. Could you explain how file wrapper Estoppel works and why it's important?
Yeah, so file wrapper Estoppel, first of all, it has, I think, half a dozen different names, whether file wrapper Estoppel or Festo Estoppel. It came from a case in the US by the name of Festo, prosecution history Estoppel. So many different names for the same concept, but it basically prevents a patent owner from being a hypocrite. And what I mean by that is it prevents a patent owner from making arguments to obtain the patent during prosecution and then contradicting those same arguments when asserting the patent for the purposes of doctrine of equivalence. So to give an example, you can't argue during prosecution, our invention is different than the prior art because whatever. And then later when enforcing the patent, argue, well, no, just kidding. Our patent is actually broad enough to cover that which we defined over during prosecution. And that seems very common sense to say that you can't obtain a patent by amending or even making arguments during prosecution and then through doctrine of equivalence obtain what is essentially an invalid patent. But the policy behind this is to ensure that the patentee does not abuse the doctrine of equivalence to cover more than what was rightfully granted in the first place. And based on file wrapper Estoppel, patent prosecutors oftentimes have a certain hesitancy to expand upon their arguments on paper during prosecution. And there are a lot of tips and helpful practice tips that we can glean from this very topic.
Wow, that's pretty interesting. So then now if we shift to a case of potential literal infringement, how relevant is the file history in such cases? And does the file wrapper Estoppel or the prosecution history still play a significant role? I'd be curious to know.
Yes, I'm glad you brought that up because the application of doctrine of equivalence is actually quite rare in the US. It exists in every litigation case virtually, but we don't often win or lose on the doctrine of equivalence. However, the prosecution history is important in several respects. First, it's important for me when litigating a case to understand what the boundaries of patentability are. I often like to look at the prosecution history to see how the patent was allowed, what was that line between patentable and unpatentable. You have this thing come to life, right? I think that's an important thing to look at in the first instance to see whether where the rubber hits the road, so to speak. But also in litigation, we use the prosecution history for claim construction purposes. We're constantly reviewing what the applicant said to distinguish the claims over the prior art to see whether it fits our non-infringement position. And so that's really where the prosecution history plays a part in U.S. cases, is during claim construction. It's not the most important part for claim construction. Of course, the plain meaning of the claims is most important, then what the specification says, and then claim construction. But it does play a part in claim construction to determine what these terms of the patent mean. And that's why patent prosecutors are so careful when they make arguments to define over the prior art, because they're always concerned that it's going to come back to bite them during prosecution when a defendant is trying to characterize the patent claims as meaning something that does not cover their client's product.
Wow, that's pretty interesting. So there's a little bit of a fear factor involved there, would you say?
There's always a fear factor, George, when you're prosecuting patents. And when I do a lot of prosecution and litigation, and when prosecuting, I'm always envisioning a litigator on the other side, sort of looking over my shoulder, trying to find where the holes are. And so fear factor is unfortunately the name of the game, and it's part of the job. But that's very much the right approach, unfortunately, to drafting patents here in the U.S., because the arguments and amendments during prosecution can very much come back to bite you.
Wow, that's great. That's interesting to know. Tilman, is there a comparable concept of the file wrapper estoppel within the UPC framework, or do European courts handle it differently?
Not that differently, as far as I understand now. But maybe one other question to Pat, to you. When I compare now the situation for equivalent patent infringement and literal patent infringement, and then look how far the prosecution file might play a role, is my understanding correct that if the case is about equivalent patent infringement, there's no way to say, let's say, something different than during prosecution? Therefore, maybe the wording is Estoppel. And whilst when it's about literal patent infringement, I can still say, well, I submitted this explanation X, Y, Z, but now I believe I was wrong, and now I want to argue differently. Is that a bit the difference between equivalent and literal patent infringement in view of the file wrapper estoppel, or am I wrong?
It's a good point.
You make a good point, and the reality is, when you make arguments during prosecution in the U.S., oftentimes the relevance to those arguments is obviously in obtaining the patent, but also in determining the scope of the patent terms. And so the relevance of those arguments is respect to the patent terms. Now, if those arguments are not successful, then later on you can argue that, well, these arguments or amendments were not for the purposes of obtaining patentability. They were not successful. And so we changed our mind and sort of reversed course, and we obtained the patent on different grounds. That sometimes can help, sometimes not. It's a bit of a fuzzy area. But the reality is, when crafting arguments and amendments during prosecution, I find it best to less is more. The fewer words and the fewer arguments you make, the better your patent will be in terms of being picked apart down the road. And then also there's certain things we can do to limit what arguments are on paper. For example, examiner interviews, which are either telephonic or video conversations with the examiner, where you discuss the application with the examiner over the phone. There is a written record of that, but it's not a word-for-word record. It is a summary from the examiner, maybe a couple sentences of what you talked about. And oftentimes you can keep these more detailed arguments off paper and avoid this prosecution history estoppel or even claim construction arguments that we're referring to here.
Very interesting. I mean, George, coming back to your question regarding the situation in Europe, I mean, under the UPC framework, the role of a potential prosecution history in claim interpretation, and whether a doctrine similar to the file wrapper estoppel in the US applies, remains actually unresolved so far, because different approaches have been taken by various local divisions. The Munich local division, for example, has explicitly recognized a file wrapper estoppel, and meaning that they found that the statements and amendments made during prosecution can limit interpretation of claims and restrict a patentee's ability to argue for broader claim scope. In contrast, the Düsseldorf local division has taken several times, meanwhile, the opposite stance, ruling that the prosecution history should not restrict the claim interpretation. On the other hand, and there I find a similarity to the US situation actually, also Düsseldorf makes the point that any submissions during prosecution are not entirely irrelevant and might play a role for the question how the person skilled in the art understands a certain feature of the claim. The Court of Appeal has not decided on that issue yet. Actually, it even explicitly refused to answer that question. From a recent decision, however, you may derive that the Court of Appeal at least follows the Düsseldorf approach, so they at least put some weight on the submissions of the patentee during prosecution. Whether or not they go as far as the Munich local division and maybe more fire rep Estoppel in a narrow sense, I have my doubts, but it has to be seen.
Yeah, okay. Then, I mean, that's pretty interesting. Then, Pat, I have a quick question for you, because like Tilman was saying, things differ between, for instance, the Dusseldorf courts and the Munich courts, or, or maybe the UK courts, of course. Is that the same as, like, for instance, California, Chicago, and Florida may have a different opinion on things?
So no, under U.S. law, patent law is federal law. It is law that is governed countrywide. And so there are courts that have different, shall we say, styles. And I'll leave it there. But they're supposed to apply the law equally, and then all of our lower courts, which we call district courts, appeal to the same circuit court, which is the Federal Circuit Court in Washington, D.C., which then appeals to the U.S. Supreme Court. So there's a very structured system here that provides what is supposed to be a uniform application of the law all across the country. That's, of course, not true in practical matters. And large tech companies are always trying to get out of various courts that they feel are unfair to them. But in general, the California courts, the Texas courts, the Delaware courts, I'm in Chicago, the Illinois courts, we're all supposed to be the same, and we're supposed to apply these legal principles the same.
Excellent to know. So then I have a question for both of you, and we'll figure out who goes first. But how do these doctrines influence claim construction and litigation strategies for patent owners in their respective jurisdictions? Which is a little bit like what we were saying. But we'll start off with Tilman. Yeah.
Several decisions follow a different approach. Munich has another view on that compared with the Düsseldorf division. So before even starting the litigation, you should actually analyze what fits to your case. I mean, if, for example, there is a risk that some submission during prosecution is detrimental for patent infringement for you as a claimant, then of course might not be the best way to go to the Munich division. Then you should choose maybe the Düsseldorf division.
Pat, what do you think? How do the doctrines influence claim construction and litigation strategies for patent owners in their respective jurisdictions? Like, I guess there's not too much with the federal system that you're working under in the U.S., but that would be an interesting question.
Yes, and it's interesting because Tilman mentioned earlier in Germany how the prosecution history is not determinative. And if I'm misquoting you, Tilman, I apologize, but that's very similar in the U.S., where we oftentimes look to the prosecution history and give it maybe a little bit too much weight as the attorneys, and then the law itself says, well, no, it's important. It kind of helps in some ways, but the plain meaning of the words of the claims are really what matters. And then only when the patent owner is defining those words in a different way do you then look at the specification and the prosecution history to help understand what the meaning is behind those words. And so in many ways, the prosecution history is relevant to litigation strategies in the sense of, okay, well, let's look at the prosecution history. Let's see what it says, because that can help us understand what the boundaries of the patent really are. But in a practical sense and in a legal sense, the prosecution history plays a less important role than sometimes we may think or want when looking at these things in the first instance.
Oh, that's pretty interesting. So then we'll get to the next part of it, which would be practical implications and litigation strategies. Now this becomes fun. Pat, in the US, what challenges do patent holders face when asserting equivalent infringement, and especially when the risk of the filed wrapper Estoppel coming into play can be pretty, dicey?
Yeah, George, you're absolutely right. In the premise of your question, there are so many challenges when asserting equivalent infringement, we've gone over prosecution history, Estoppel, and how that can sort of bite you and say, well, no, you can't go beyond that which you distinguished over during prosecution. The other more practical issue is that judges and juries hate it. The judges, it's a question of law, of facts, and so the jury must decide whether or not the doctrine of equivalence is met, but judges can step in for issues such as prosecution history, Estoppel, and what we call disparagement, which I'll go over in a minute.
Mm-hmm.
But the bottom line is judges and juries hate it. And the reason is pretty simple. They're saying, well, if that's your invention, then why doesn't the claim cover it literally? Why are you asking the judge and the jury to expand the scope of your patent claim beyond which it literally states? And that's sort of the policy against the doctrine of equivalence applying, is that the purpose of the patent is to provide notice to the public as to what is protected and not protected. And so if we can now, in a sense, enlarge the scope of the patent, then that notice function goes out the window. And so there are policy implications, and then, as I mentioned earlier, the legal implications and legal principles that limit the application of the doctrine. Again, we mentioned file wrapper, Estoppel, and then disparagement. Disparagement is when you, if you will, speak ill of a prior art device in the specification. So, for example, if you say, well, the prior art is no good, you say this in the spec, it's no good because it's made of steel. And then your invention applies that to aluminum. And then if the infringing product that you're asserting the patent against in litigation is made of steel, then it becomes more difficult to argue under the doctrine of equivalence that infringing product really does infringe.
Tilman, how does the balance between literal infringement and equivalent infringement affect litigation outcomes at the UPC? And is there a tendency to favor one approach over the other?
Yeah, it's difficult to say. I mean, still we do not have so many cases on that, but this shows already something. Coming maybe from the national practice, not only in Germany, but maybe also in the Netherlands or France, the vast majority, I would say, of all cases is based on alleged literal patent infringement. So it's not so remote from what Pat was explaining for the US situation. At the UPC, on the other hand, out of maybe 100 cases, meanwhile, decided, probably more, we have 3 decisions on equivalent patent infringement.
Okay.
And only one of these 3 cases was in the end successful. Whether you call this statistics or not, at least it's a first hint that it might be difficult also in the future to be successful in a case for equivalent infringement. In the end, it is always very difficult when you do not actually fulfill the wording of the claim and then still argue, well, yeah, from another perspective, you do fulfill the patent wording. This is difficult, and in most cases also not kind of a fair result. And the judges, of course, are looking for a fair and just result in the end.
Well, hey guys, that was excellent advice, and it was great to have this U.S. and European mindset of the differences and maybe some things that coincide together. But that's going to wrap it up for today's discussion on equivalent patent infringement and file wrapper Estoppel. Big thanks to you, our guest, Pat Muffo. Thank you very much for taking time out of your busy schedule. I mean, I know with the time difference and everything, we really appreciate it, and hopefully we can get you back on the show again.
Thank you, George, and thank you, Tilman, for having me on.
Tilman,
thanks, Pat.
You as always, Tilman Pfrang, our expert UPC man here in Europe and in Munich, and a colleague of mine. Fantastic work as always. For patent holders and legal professionals, understanding how these doctrines operate across different jurisdictions is crucial for effective enforcement and defense strategies. We hope you found today's episode informative. I know I did, and it was great to have Pat Muffo on today, and also Tilman Pfrang, you're always doing a great job and expertise in finding great guests for us on the show. As always, don't forget to check out our past episodes on topics like the SEP disputes and UPC rulings. Subscribe to UPC Insights, whether you get your podcast, and if you have any questions or suggestions for the future topics, feel free to reach out and join us. Until next time, I'm George Walden. On behalf of Pat Muffo and Tilman Pfrang, see you soon und auf Wiedersehen.
Auf Wiedersehen, George.